screen with you. Is the screen visible? Can you kindly confirm if whether the screen which I'm sharing is also visible on the other side?
Yes, it is.
Oh, okay. Thank you so much. Today's lecture will be focusing on the supervision of local government by the national and provincial spheres of government. Actually, the national government is also, to a certain extent, obliged to supervise the provincial level of government or sphere of government. However, in most cases, find that it is the local sphere of government that has got so many issues or unintended consequences when it exercises its powers without proper supervision from higher levels of government. Some of the issues that are often encountered include corruption and resource wastage. There are two main purposes for supervision of local government. The framework for supervising local government is designed to ensure that local governments can comply with the constitutional, legal, and policy framework, and that it should be able to perform its obligations according to the given legal framework. Generally, there are four categories or forms of supervision, which is regulation, monitoring, support, and intervention.
Speaker, no, don't.
The first form of supervision is regulation. With regulation, the national government retains the power to set the national framework within which local government can exercise its powers and undertake its functions. For example, the national government sets regulatory frameworks for the establishment of governance structures and procedures, the minimum requirements for key managerial positions, and the norms and standards relating to public service provision, for instance, water quality. This framework should, however, not go to the core of these functions because that will violate the local autonomy which is conferred on the local government. They should also be predictable, given that it will be difficult for local governments to comply with regulatory frameworks that are constantly changing. In certain instances, there is what is often referred to as the strangulation of local government, where there is a number of overlapping or a hybrid of provisions that are coming from different legislative provisions that in its own, it causes strangulation to local government's capacity in terms of fulfilling its statutory obligations. The form of supervision should not violate the local spheres of government, the right to autonomy, which is the right to govern its own affairs without the encroachment or interference from the national and provincial spheres of government. Financial regulation particularly is important in order to address issues such as corruption and resource wastage. The second form of supervision is monitoring. Monitoring is used in order to establish mechanisms to assess the performance of municipalities and also to check if whether they comply with the regulatory frameworks. They also help in terms of reviewing periodical reports on the set performance targets and also in the officials or certain delegates from the national or provincial governments. They also undertake periodical visit in municipalities' offices just to check if whether there is full compliance with the regulatory frameworks. One of the main or key needs for monitoring is the usage of fiscal monitoring mechanisms, where they are auditing financial books and systems that are used in the local government structures. The monitoring form of supervision are not too intrusive as opposed to other forms of supervision. Then the third form of supervision is support, where monitoring has revealed problems in the local sphere of government. Then there is a need for a municipality to be supported. Some of the municipalities that are displaying issues that actually need support, they are purely resourced municipalities which often display the lack of capacity to comply or to perform. The form of support that is often offered to municipalities, it is usually through capacity building, the deployment of staff and resources, as well as the intergovernmental grants that are meant to ensure that its financial capabilities are actually able to ensure that they fulfill their executive obligations or perform their functions without lack of the requisite resources. Then another issue is the local autonomy of local government. If the support is to be offered to aiding municipalities, there is a need not to encroach on their autonomy because they've got the right and ability to function on their own, but their institutional integrity still needs to be protected. That's why there is a high level of constitutional protection of the local sphere of government. Intervention, which is the most intrusive form of supervision. The interventionist measures are taken when the monitoring and support mechanisms reveal persistent problems. Usually, intervention is taken when the crisis at local level of government, they threaten, the attainment of national or local goals. Intervention powers must be taken through three procedures. They need to be limited by the law. Then the grounds for exercising intervention powers have to be explicitly provided for in the law, and they are supposed to ensure that there are oversight mechanisms that check if whether the exercise of intervention powers are actually according to the law. There are three guiding concepts with regards to the general supervision of local spheres of government. The first one is the part of autonomy, which I've also explained. So there has to be a final say or discretion for the local governments. Then the second one is supervision, where the higher levels of government, they supervise the local government. These constitute an unequal relationship. Therefore, one could see clearly that as much as the supporters of the term sphere, they speak of cooperation, but at one point in time, one could see that there is a certain level of hierarchy and an equal relationship. Then the third part is the cooperation, that is the local government has to cooperate with the other spheres of government in accordance to the principles of cooperative government and intergovernmental relations, which are stipulated in section 41. Do not forget that during the two previous lectures, we did engage on the form of South Africa's multi-sphere of government, and we indicated that it's a quasi-federalism where there are classical features of a federal state that are replicated in the South Africa's constitution. Then the question is, who is responsible for local government? In the USA, Australia, and Ethiopia, where there is dual federalism, a local government is a competence of the states, which could mean the provinces. They are the ones which are constitutionally obligated to supervise local governments. Then there is an evolution of how the federal system functions. In other states, local government is a part of the federal state. This is the same as in South Africa. Then another question deals with the zero-sum game, where the local government is conferred more powers as opposed to the provinces. This is applicable in South Africa. Now we'll deal with the constitutional framework for supervision in South Africa. The autonomy of local government is provided for in terms of section 150, section 151, subsection 3 of the Constitution, that provides that a municipality has the right to govern on its own initiative the local government affairs of its community, subject to the national and provincial legislation as provided for in the Constitution. And again, if you look at some of the principles of cooperative governance and intergovernmental relations, they support the autonomy of local governments. Section 41, subsection 1, F and G, they provide that the different spheres of government are not supposed to assume any power or function except those conferred on them in terms of the Constitution, and that they exercise such powers and perform their functions in a manner that does not encroach on the geographical, functional, or institutional integrity of another sphere of government, meaning the constitutional protection of the autonomous state of the local government is fully secured. Then with supervision, the provisions for regulations are in section 155 subsection 7, then for monitoring is section 155 subsection 6, then for regulation is section 1541, then for intervention is section 139 subsection 1. With the cooperation is under section 41 subsection 1. The local sphere of government is recognized as the weakest because it lacks the capacity to exercise its powers. That's why the Constitution has inherently ensured that the higher or senior levels of government are conferred with the supervisory powers to supervise the local government. These four categories of supervisory powers are also enshrined in South Africa's constitution. With regulation, it is provided under section 155 subsection 7. It states that the national government and the provincial governments have the legislative and executive authority to see to the effective performance by municipalities of their functions in respect of matters listed in Schedule 4 and 5 by regulating the exercise of municipalities of their executive authority that is referred to in section 156 subsection 1 of the Constitution. In the first certification judgment, the court held that regulation, it means to control the manner in which a municipality manages its own affairs. However, to be conferred the regulatory powers as part of the supervision of local government does not mean the powers that are constitutionally or assigned to local governments through legislation are actually withdrawn from the local government, then conferred ultimately to the senior levels of government. This is because the main objectives for regulation is to establish a framework for municipal performance than to withdraw the performance of such functions from it. The second form of supervision is monitoring. This is provided under section 155 subsection 6 of the Constitution, which states that each provincial government must establish municipalities in its province in a manner that is consistent with legislation, and it must provide for the monitoring and support of local governments in the province. This duty also includes the obligation to promote the development of local government capacity to enable municipalities to perform their functions and to manage their affairs. This does not mean the provincial government is then conferred with the authority to control municipalities. Monitoring, among the four different forms of supervisory powers, the monitoring is the least or the less most intrusive form of supervision. Then support is about ensuring that where crises or problems have been found in municipalities, they are able to be given the requisite support. This is provided under section 154 subsection 1 of the Constitution, which states that the national government and provincial governments must support and strengthen the capacity of municipalities to manage their affairs, to exercise their powers, and to perform their functions. Again, in the first certification judgment, the court held that to support, it means to strengthen a municipality's ability to manage its affairs. The objective of support is to prevent the decline or degradation in municipalities' existing structures, powers, and functions. And the supervisory power of support is more intrusive than that power of monitoring. Then the last and the most intrusive form of supervisory powers is intervention. The first certification judgment also states that intervention, it means now the national and provincial spheres of government have got the power to intrude on the functional terrain of local governments. However, this power is restricted and subject to procedural requirements laid down by the law. Up to date, there are close to 80 interventions since 1998. Section 139, subsection 1 of the Constitution, it provides for 3 different steps that are meant to ensure that the intervention is according to the law. It states that the relevant provincial executive may intervene by taking any appropriate steps to ensure the fulfillment of the obligation, which include issuing a directive to the municipal council describing the extent of the failure to fulfill its obligations and stating any steps required to meet its obligations. Second, by assuming responsibility for the relevant obligation in that municipality to the extent necessary to maintain essential national standards or meet established minimum standards for the rendering of a service, to prevent that municipal council from taking unreasonable action that is prejudicial to the interest of another municipality or province as a whole, or to maintain economic unity. The third possible step is to dissolve the municipal council and appoint an administrator until a newly elected municipal council has been declared elected. There are 4 procedural requirements for assuming the responsibility of a municipality. The intervention has to be linked or be in respect of a particular obligation. It needs to be meant to maintain an essential national standards or minimum standards that are set for the entire province, or it should be meant to prevent the prejudicial consequences that arise from unreasonable action by that municipality, and to maintain economic unity within the province itself. What is the meaning of appropriate steps? In the case of Nguma local municipality and another versus the Premier of the Eastern Cape and others, the court rejected the method that dissolution should be resorted as a measure of last resort or the last step of intervention. And the court also rejected the interpretation that appropriate steps means the process of comprising of a set of successive steps, where others could say is the least intrusive form of supervision to the one which is the most intrusive. Then the court stated that appropriate step could be taken in the alternative, meaning if a municipality is failing to fulfill its executive obligation, a provincial government could just decide straight away to intervene. The province may choose between the steps that are outlined in section 139. Dissolving the municipal council, assuming the responsibility or issuing a directive to a municipal council by stating the extent of the failure and any steps that needs to be taken in order to fulfill the obligation. And the question is when the court in the case of Noma decides that the appropriate steps could be taken anyhow without checking first whether the decision that is being taken to intervene is intrusive or not. Does this cause the last resort principle to be lost? There are other forms of intervention. Again, the first one is under section 139 subsection 4 of the Constitution that provides that if a municipality cannot or does not fulfill an obligation in terms of the Constitution or legislation to approve a budget or any revenue raising measures necessary to give effect to the budget, the relevant provincial executive must intervene by taking any appropriate steps to ensure that the budget or those revenue raising measures are approved. One of these steps includes dissolving the municipal council and appointing an administrator until a newly elected municipal council has been declared elected, or approving a temporary budget or revenue raising measures to provide for the continued functioning of the municipality. The other reason for intervention is under section 139 subsection 5, where if a municipality, as a result of crisis in its financial affairs, is in a serious or persistent material breach of its obligation to provide basic services or to meet its financial commitments, or admit that it is unable to meet its obligations or financial commitments, then the provincial government or executive needs to intervene as well. The Constitution puts emphasis that where a municipality fails or does not fulfill its executive obligation, and the question is, what is an executive obligation? In the Muma case, the court tried to make a distinction between executive obligations against the statutory ones. It held that the failure to fulfill a statutory obligation would not necessarily result in a failure to fulfill an executive obligation, because these two obligations cannot be equated. They are different. And the court tries to cite the Constitution where there is a provision that provides that the executive and legislative authority of a municipality is vested in its municipal council. Therefore, at the local sphere of government, there is no separation of powers, as both the executive and legislative authorities or powers are conferred on the same municipal council. Furtherly, the court declared that the executive obligation is limited by the functional areas that are conferred on the municipality as listed in Schedule 4B and 5B of the Constitution. Then the executive obligation, according to the court, it's more about the development of policy, initiation of legislation, and the rendering of basic services and facilities to the communities. In the 2011 case of a Premier of the Western Cape versus Overberg Municipality, we saw the judiciary changing the decision of the Mnguma case. In this case, the court held that the failure to approve a budget or revenue-raising measures necessitate provincial intervention, and that the province is obliged to take some steps, but it is still not obliged to intervene, and that the province may decide on the form of intervention required, but the steps taken must be appropriate and suitable. And the province again has to consider less drastic measures before resorting to the dissolution of the municipal council. This is in stark contrast to the court's decision in the Mnguma case, where the court dismissed the method of the principle of last resort by indicating that the word appropriate concept, it also includes any alternative measure. Instead of emphasizing on the provincial government just randomly picking any form of intervention, here in this case, the court is saying dissolution needs to be taken as a measure of last resort when all other less intrusive forms of supervision have been exhausted, and that there is a need for an appropriate step that needs to be taken in a very objective manner than to be taken out of the blue without the requisite procedures. Another requirement before a provincial government can intervene is that it needs to identify a statutory provision that places a duty to fulfill a certain obligation. A general reference to a municipality's failure to fulfill its executive obligation cannot be considered I just provided a very short lecture, and I can now open up to questions. Class, hello, are you still there?
Yes, we're still around, yeah.
Oh, okay. So I just provided a very short lecture. So the slides as they have completed means I'm done with the main lecture of today. Then I'm opening up for the question and answer session.
Hi, sir. How are you? Good. I just want to check. One of previous slides, I can't remember. I wanted to know where you talk about the intervention, and I can't remember the other word. I wanted to know what is the difference between the two. If you maybe can just go a little bit back to your slides.
I'm not sure if I got chance. Can you please repeat your question?
There is where I think you mentioned that I think intervention is different from, I can't remember the word. Go back.
So mind you, there are 4 forms of supervision: regulation, monitoring, support and intervention. I'm not sure if whether you are trying to.
Yeah, under intervention. I think under intervention you mentioned something quickly, and when I wanted to write it down, I think you passed quickly there.
Yeah.
Okay. No, okay, it's not here, but it's fine. But it was under intervention. I think, yeah. You say to intervene, it was not the same as that's the name.
Oh, okay. So I will suggest that since you are not quite sure of the question which you want to pose, so far I can just open up the questioning from other people. You will be still be trying to find out the actual questions which you wanted to pose.
I think it intervene and interfere or something like that. Or you mentioned something to that effect. Say they were not the same. So I wanted you to just explain to me. They sound the same to me, but you said they're not the same. But yeah.
No, they're not the same because with the interference, which it's possible that the higher levels of government might try to influence how a municipality must perform its functions or exercise its powers. Then with the intervention, it could be about taking that very same power from the municipality to be exercised by the senior levels of government. So that's how different intervention and interference are with regards to the autonomy of local government.
Thank you.
All right. Are we having more questions? I see one question. It says that when will the slides be posted? I think they could be posted as soon as I've sent them to Professor Lee Stone, because she's the one who's responsible in terms of sharing the lecture slides. Then immediately after the lecture, I will email them to her. I see that there is a hand from Toby.
Yes, Mr. Modao, thank you so much. I just wanted to remind you, please, to pass on the message to Prof. Stone. Last week, she requested all those who have a problem to access the link to email her, because we can't still retrieve the info from the link because I'm one of the students that are not listed as registered for this module. So I don't have access at all. So I first need the lecturers to recognize me and capture me as one of the students so that I can have access to the shared server and view and listen to the previous lectures, please. So until that is done, I'm basically stuck.
All right, so sorry for your inconvenience. I'll actually try to give you a direct call immediately after the lecture.
Thank you. She must just check the emails of last week. Thanks.
All right. Yep. Are we having more questions? I'll give you almost 2 to 3 minutes. If we do not have questions, then that will be the end of the lecture.
Hi, Mr. Modao, it's Melissa speaking. Before you end the lecture, I'd just like to ask my colleague that spoke last, would she like me to post the link to the past lectures in the chat box now? Thank you.
Tobile,
Yes, Mr. Modau, you were saying?
did you hear the question?
No, what was the question? Sorry.
Can you repeat it, Melissa?
Not a problem. Tibile, would you like me to post the link to the past lectures in the chat box now so you can try and access them? Thank you.
Yes, please. Yes, that will help. Thank you so much.
Okay, I'll do that now. Thank you.
Thanks. It seems like we do not have more questions. I'm not sure, perhaps it's the failure to fully comprehend the complex section of multi-sphere of government, or is because people, they outrightly understood the content that was being imparted onto you during the lecture. So if we no longer have questions, then I would like to officially declare that the lecture has come to an end.
Can I just ask something quickly, please?
Oh, okay, it's fine.
I just want to know, how many more lectures do we have? Are we going to have revision classes, or where are we in the program?
Oh, okay. Let me quickly look at the updated lecture series, and I think we were still supposed to have it's 3 more lectures. No, it's 2. These will be provided by Prof. Shai. One will deal with the general discussion on aspects that are particularly complex and confusing, and the other, it will be revision and exam preparation. Yeah, so these are the 2 outstanding lectures which I'm just seeing now from the updated schedule for the lectures, unless otherwise.
Okay, so then we're actually done with the content of the whole module, and it's now left with the 2 lectures for the very confusing stuff and a revision lecture.
I think so, unless
Okay.
otherwise, since I will have to consult with Prof. Leastone and Professor Isaac Shai, the other co-lecturer, just to fully establish whether the lectures completed. But so far from the updated schedule for online lectures, I think we're just left with 2.
Okay.
Any further developments, I guess, will be shared with you.
Yes, if they can just send us announcements, that would be great, because we can follow if it's on announcements. Thank you, sir.
All right. Thank you. Is there any other hand? Yes, from Singh.
Good afternoon, Mr. Nadal.
Good
I'd
afternoon.
appreciate if you please summarize what federalism means.
I did not hear your question properly. You are inaudible. Can you please repeat?
Can you hear me now?
Yes.
If you could please summarize what federalism means.
I'm sorry, I can't hear you unless someone just heard the question which you posed.
If you could summarize what federalism means or quasi-federalism.
Oh, okay, thanks a lot. Quasi-federalism is a form of federalism where there is a mixture of both the elements of a federal state or a federal system mixed with the elements of a unitary system. With a unitary system, you find that there is a very strong national government where power is concentrated on the national government. In other countries, the power is concentrated on the president or the presidency or the prime minister. Then with a quasi-federal state like here in South Africa, you find that you still have a more of a stronger national government that is conferred with substantive powers, but there are provincial and local governments that also they govern their own areas or geographical areas. So in a federal state, the equivalent of a province is called a state. These powers are protected by the constitution, so none must encroach on the powers of the other sphere or a level of government. And a typical federal state has got a supreme constitution that establishes different levels of spheres of government. And that very same constitution, it ensures that there are principles of intergovernmental relations like we see here in South Africa. It also provides for mechanisms for intergovernmental conflicts like you find here in South Africa. And it also provides for the autonomy of different spheres of government. But you may find that in the context of other states, such things are not happening, like in Zimbabwe, where everything is concentrated on the national government, which delegates powers through national legislation. But in the context of a quasi-federal state, each and every sphere of government has got its own constitutionally protected powers.
Thank you very much, sir. Really appreciate that.
My pleasure.
So can I ask, can you maybe just go back to your very first slide?
Okay. Are you referring in terms of today's lecture or
Yes,
the?
yes, for today's lecture. I just want to, that's no, on your first slide. Purpose of supervision. It was the purpose of supervision. I just want to make sure that I was a few minutes late. I just want to make sure that I didn't miss too much. Then there was the form. No, okay. No, thank you, sir. No, I'm fine.
Oh,
Thank you very much.
my pleasure. Do we have more hands?
Thank you for the
It
lecture,
seems.
sir.
Oh, okay. Then we've come to the end of the lecture. So any further information concerning upcoming lectures, you will be informed on time. Thank you so much. Bye-bye.
Thank you, Mr. Mdau.
Thank you, sir.
Rollywood, thanks.